have CJ. CJ is our COO, and he also does sales at BHIS for business capture, as we call it. So thank you for coming. And CJ, take it away. Let me know when you want me to flip the slide.
Awesome. So Sierra made me follow the Black Hills theme of adventure. So this is the spring storm warning, general data protection regulation, because this is going to be a storm, but it's not going to be a snowstorm. It reminds me a little bit of Y2K. For those of you who were around back then, there was quite a bit of hype, but there was also some real behind it. So this is like Y2K, but with lawyers, governments, and bureaucrats involved. So obviously it's going to be
more fun.
Yeah, 3 times the fun. And it's going to be like a real storm, and it's going to probably hit us in bands. It'll come around, that backside band will come around and hit us multiple times because there's a lot of weird stuff. I also know this is the 11th hour for GDPR since it goes into effect May 25th. I've been watching all the GDPR webcasts and things that come out from other places. Little concerned with the hype I see, because what I see is the people presenting those are the consultants that are doing the consulting on that. So it's a little bit, the sky is falling, and you need us right away, and you're way behind the power curve, which is true. For big companies, multinational companies, they are way behind the power curve. For the US companies, we'll see. So go on to slide 2, Sierra. So what is this thing, right? This is European Union regulation came out. It's a follow-on for their data protection directive, which has been out since 1995. So some of these principles and things been around a while. This is their attempt to sort of upgrade it, modernize it a little bit. Mostly they radically expanded it. So I strongly suggest if you have any customer and any data of anyone who might be from the EU, you might want to check this out. So I would actually download the law. It's 88 pages, not terrible. Makes a lot of sense, but attending this is going to educate you a little bit, doing some other education. If you're a big enough company, you're going to want to talk to your big enough country. If you're a big enough company, you're going to want to talk to counsel on this, on some of the things. Again, there's a lot of hype here, but I think some of this is just sort of best practice. And so we're going to talk at the end of what our recommendations are, what sort of things you need to do. Things actually that Black Hills Information Security hasn't quite done. And I'll use us as sort of a test case to talk about the small business. This is somewhat oriented towards small and mid-sized enterprises, but we'll have something for everybody here. So let's go on to my break for a rant.
Ooh, the first one.
Yes, we'll get this out of the way because this is my strong libertarian reaction to this sort of thing. So number one, it's big government, and it's not just big government, it's government outside the US. So we didn't vote for any of the people that implemented this law. We didn't have a whole lot of input on the law. I guess the major corporations like the Googles and the Facebooks and people such like that probably have lobbying groups, which everyone hates lobbying groups, right? Except that lobbying actually helps industry have a voice in what's coming down the pipe. So the EU has been a lot bigger on privacy than we have, notably like the FISA courts and things like that, right? But just generally ahead of the curve. But even in the EU, you have countries like Germany, which are pretty rough on privacy, or more strict, I'd say, pretty rough on it. And then you've got looser countries within the EU. So this was made to sort of normalize things. They said it was to level the playing field. But one of the things this thing does is anytime you start letting government and large bodies decide how you're going to do something as complex and intricate as information security, you're in for a mess. This is a bit of a one-size-fits-all thing, right? I tend to be on the libertarian side. I'm for competition. I like to see which is the best standard and what we do with that. But no, it's now being crammed down our throat. So. And kind of the idea of negative rights versus positive rights. So now you're getting deep into my philosophical realm. Negative rights are things like don't kill other people. You can't stop other people's free speech. And you get to the positive rights where you have to do things for people. So they created a bunch of new rights, like the right to be forgotten. seems a little odd, the right to be forgotten, but this is affecting people like Google search engines, right? So, so now you don't just have the right to do something that you can go out and do it by natural right. No, other people have to actually go out and actively perform things in order for that to be sustained. So real quick, so one of the big things here too for me is this jurisdictional issue, right? So you've got the EU legislating a law, and guess what? It's going to apply to everyone. And it doesn't matter where you are. So that's a big question. Where the heck is the internet, right? Well, it's right here on my screen. I see the internet right there. Is it in Colorado? Is it in South Dakota? Is it in the US? It's worldwide, and it's everywhere. So when the EU passes this law, and they mandated that anyone who's an EU citizen, if you've got an EU citizen's data, their name and email address, let's just take that for the starter, like Black Hills collects, you are now subject to this law. Now, exactly how are they going to get you into court? For somebody as small as Black Hills Information Security, that might be a real tough stretch for them to drag us into a European court. We have nothing there. But there's an interesting case, this Google Spain case from 2014, which actually took place mostly under that DPD directive, but they had the right to be forgotten there. So there's a Spanish guy, Costega Gonzalez, and he had been in the newspapers in a legal case. And he approached both the newspaper and Google and was asking for that right to be forgotten to be implemented. He wanted his stuff not to be found when you did a Google search on him. Google resisted. They're a California company. They've got lots of EU subsidiaries. They primarily operate out of Ireland, which if it's good enough for Google, you definitely want to think about that if you've got an EU presence. But they ended up getting dragged into Spanish court because Google had some advertising offices there that basically dealt more administratively, right? It wasn't where the data resided. It's not where they were running the search engine. They just had employees there. And because they had employees there, they got dragged into the Spanish court. So that's kind of the chain of things that you see when people say, is this going to apply to us? It certainly applied to Google. And I doubt most of us have lawyers quite as good as Google. So let's go on to the next slide now that my rant is mostly done.
Well, we have 6 of them to get through. Just kidding. We have a couple questions, and maybe Excellent. This is something you're going to cover. But Bob asks if you could clarify the DPO provision that buggered up this regulation. Are you going to talk about that later? Maybe we don't want to.
So DPO is the Data Protection Officer? I believe I'm talking about that later, if that's not Bob.
Okay, so Bob, if that's not it, then go ahead and ask again, but we'll get to that later. And then, yes, he says that is it. So we'll get to that in a bit. And then Holly has another question, and she says, does this apply to the UN? I'm actually currently dealing with a UN website that's gathering user data, users from all over the world. So
Absolutely, yes, no question. So as soon as you have an EU citizen's data, it applies. And my guess with the UN, because a lot of what they're going to collect is health data and things like that, they have this category called sensitive personal data, which interestingly is on this slide. So go to the next slides here. There's what is personal data. So we'll get to this right here. So the law only applies to personal data. It doesn't apply to all the data, only data associated with a real person. So once your name is there, you're in. Here's another little intricate thing, because here was my clever idea how to manipulate the law, right? Well, we can have a question when they're signing our web form that says, are you an EU citizen? And if they answer yes, we'll just drop it, right? But they say as soon as they type anything in there, including, yes, I'm an EU citizen, you're now subject to the law. So beautiful, isn't it? So
Robert points out EU individual is not the same as an EU citizen. Can you clarify that, Robert?
EU persons, actually. So if Sierra's living in the EU, you're protected by this law.
Oh. How about EU citizens residing outside of the EU?
Yes.
Yes, all the things. How about American citizens living in the EU?
Yes.
It's a storm. It's a storm.
Remember when I talked about judicial overreach? That's what we're looking at.
Okay, anyway, continue on.
Oh, so remember, I am not a lawyer, though I could play one on TV, and I did stay in a Holiday Inn Express last night. So I serve as the legal counsel around here. So these are not the opinions of a lawyer. Please seek out your own attorney. Go get alternative opinions. These are CJ's opinions, and read the law yourself and see what you think out of that. So, but personal data is all this stuff: name, ID numbers, your social security number. Interestingly, things like your location data, right? So what coordinates am I coming through when I take a picture? I don't know how some of this applies. There's going to be a tremendous amount of legal cases that are going to come out and are going to help clarify and define this 88-page monstrosity, right? A lot to figure out.
And I think 88 pages is actually kind of short for a law. So
compared to U.S. legislation, yes, but for a real, I mean, in this law, I read the whole thing. It's not terribly written, but I'm going to show you some examples in here that's just so overly broad and vague. And then now we're dependent on a court to determine what does, due diligence mean in this respect, or what's an appropriate security control. Oh, well, the court will decide. So we'll get to that. They've got this question here on sensitive personal data. So these are anything to do with your medical histories, your sexual orientation, anything genetic, your biometric data, things you're using your fingerprint to log into your phone now, or if the company's using that stuff, to have you log into their website, then all those things are now a special category of data, sensitive personal data, with additional requirements on them. So it ratchets it up. So it just defines this stuff. And then criminal data, this is talking about governments. And it'll, like I said, it'll apply to every court in the US, every city, location, county, because those people have foreigners who end up in court, right? So who doesn't this cover? It's really awesome. So that's just your legal definition of what the heck we're talking about with personal data. So let's go on to, does it apply to us, the US? And I've kind of answered this. We've talked about this a few times. Yes, if you've got that data, it surely does. And so if you're in the EU, foreign companies, including US companies, Finnish companies, South African companies, it doesn't matter. And because of the way the internet works, like with BHS, so we don't specifically market overseas, but we deal with both multinational companies, but we certainly happen across EU citizens, and that makes us subject to this. So the web, our collection form, the fact that we email all of you out there, if any of you is an EU citizen, EU person, the right legal term there, then that's what puts Black Hills under.
And we have like two that I know of. One of, I assume, a citizen, and one a person in the EU. So yes. So yeah, that's interesting. Two that I know of are even on this webcast.
Well, right, and so administratively, our admin stuff is now all subject to this, right? And so then the companies, the HR company we use, or the people that do our benefits, they've got EU data now. So this just cascades. This is the thing. The internet doesn't really have boundaries. And so, again, this is a tough legal thing to tackle in any event, and here it comes. So the physical presence in a EU country is very important, as I said, for them getting legal hold of you. So if you've got offices over there, if you have a person over there, or even like a small satellite office, that's going to make you suspect of being dragged into their court. Now, realistically, are they going to come after a BHIS? Very doubtful, right? We're a small fish. They're going to go after some very big fish and make a splash initially, is my guess.
But you could go after a small fish for legal precedence.
Right, because you're going to easily roll them over. So that'll be fun.
That's kind of scary.
Do you market to EU citizens? That's probably not that relevant. Do. Well, sure we do. We market to anybody. We're equal opportunities. And we educate anybody, right? So that's more of our bent. But yes, we happen across them, which is true of just about every business in the world. So, and like I said, the employees in an EU country, that's going to push it. And especially if you've got that employee in the EU country and they're in your HR system, boom, you're now under that, right? And those people, those persons will be able to use that against you if they need to. We'll see. The unsettled jurisdictional issues, I talked about the Spain thing. This is just going to be really fun for me to watch because I've been following it a while and I have such great opinions about it. So I'm just going to be curious. I never put anything past a court. And one thing I know is that every powerful entity continues to expand its power. So I think it'll probably outstrip my expectations on how intrusive it gets, but we shall see. All right.
Adam has a question. What about the Redress Action Law 2016, which allows for EU to file lawsuits in the US?
Yeah, that's their trump card, so to speak.
But it's just weird to me that they can make decisions. We're going to decide that we can sue you.
Yeah. So remember John's mantra, anyone can sue you anytime, anywhere, for any reason. Actually, it goes beyond that law because we're going to see this thing is winding its way kind of into the FTC. I'm going to talk about the Privacy Shield a little later. Doesn't surprise me that they've got an out that they can come sue us. I think the problem is going to be trying you in a U.S. court. This is one of those things I'm waiting to see. I'll be fascinated by if it goes to the Supreme Court and you say, where's my representation in this law? You're coming after me for this. Where's my representation? You know, how does this law apply to me? So U.S. courts will sort that out. I think we've seen the trend that people apply international standards. I know Supreme Court justices have talked about our Constitution now being impacted by ideas they've seen in other constitutions. So I put nothing past lawyers.
No, especially as we get more and more global. Bob brings up a point. If BHS does a pen test for a global company, doesn't that place you clearly in GDPR jurisdiction? Ouch. Yes, yep. I think it would.
I have no illusions about we're going to have to comply with this. So absolutely. All right, let's move on to questions on scope. So when you read the law, there's tons in there. I go over a subset in this presentation. Do we need to meet all the requirements? Yes, you do. That's a conservative answer. And I don't mean conservative politically. That's the low risk answer, that if you assume you have to comply with it all, give it a shot. You might be able to find a lawyer who's going to argue it out. Again, I'm saying you probably need to wait for some case studies. So I think you need to move down the direction of addressing them. I think in risk, and this is all risk, right? It's like weather risk, hacking risk, or legal risk. They're all risks. We need to manage this. So to me, you need to explicitly identify it. If you can't do something because of cost, I think you identify that. There's some chatter about whether small businesses have to do this or not. That's a little bit of a myth. It does apply to all businesses, even a single proprietorship. But it looked like there's some noise out there that the EU is going to be swamped with this, and they're not going to be able to deal with small companies for a while. So again, we'll see. So small companies are allowed to do things a little differently than the big companies. There's some differences in reporting, whether they expect you to have a data protection officer and things like that. So again, we'll see, I guess. All right, so no exemption for small companies. That's a myth. Assume that you're in there. And we kind of talked about in the Google thing about where's your data stored? Is it in the EU? It doesn't matter. The fact that your company has control over it is operational. And do we need to segment in-scope data? So this is similar to the PCI thing. It absolutely helps you from an audit perspective to try and contain and things. But if you think that you're going to be able to keep the EU data in the EU and not in the US, that's somewhat dependent on your architecture. But you've got to watch very, very hard on how that bleeds over. And the idea is that your company legally will still end up being involved.
It feels like trying to have a peeing section of a pool.
Very nice, Sierra. That was a good one. It's exactly impossible. Like that, including the smell. All right.
Okay, we have a couple questions coming in. Jeffrey says, the breach notification piece is still foggy on definition of what is a breach with regards to ransomware and other malware.
I couldn't agree more. We come to that in a slide. Not only that, you have 72 hours, but when do you declare? When do you know? When you suspect? you're going to be able to argue that. But
When
remember,
you smell the pee?
if you're going to have to argue it in court, you better have your ducks in a row, right? So if you've got a policy and a procedure that identifies when an incident is an incident and declared and you're following that, and that generally meets best practice, whatever that means, whoever's you choose, then, that will be operational. So, yeah.
And then he also says risk assessments will become a bigger deal, or they should.
Oh, just wait. Hold on to your hats when we get down to there. I've got a little rant around that one too.
Ooh, rant number 5 or 6. And then Matt, this is kind of a comment and a question. The RSA show should have been titled GDPR Scare and Sale. I
bet. I can't, like I said, I've been going to these webcasts and the things they're saying and the way they're pushing, it was major
it's
players,
like this
right?
year's terrifying thing.
I wanted the little Chicken Little, the one where the sky is falling. It's like, yeah.
And Matt also says, do you agree with the need to see legal precedent? He agrees. Can CJ boil down what compliance will look like? Opt-out option on websites, inform users, erase when requested, log artifacts of actions like removals. I assume you're going to talk about that. Okay. Cool.
We've got details coming up around that. Yes, indeed.
Sweet. Okay. And then, wow. Jeffrey says, can you really control your users? Good question. And
no.
And Matt, would this affect cloud use, like forcing Amazon Gov Cloud, which is limited to U.S. border and U.S. persons for admin? That's a good question. I don't know. I don't know.
I was told there'd be no math.
Well, yeah. And Jeffrey says he thinks it will. Yeah, that will be definitely interesting. Holly says, I love an AWS question. Yeah, for sure.
Amazon's going to comply with this. So Amazon,
sorry, go ahead.
Amazon's going to be, so I talk about this a little later. Outsourcing is going to be part of your management of risk on this. So we'll get into some of that hopefully down the line here. So let's go on to the next slide. The GDPR principles. So when you look at these, they're not all that bad. And after being hacked multiple times by OMB and Experian or whoever, Equifax, some of this stuff is stuff like, we all like privacy, right? And I'd like to see some of the perpetrators punished as much as the next guy. So these principles, these are motherhood and apple pie, even though they're European here. Lawful, fair, and transparent processing. Tell it to Facebook, right? Data must be collected. This is where you start to get into some of the interesting new stuff. Data must be collected for specific, explicit, and legitimate purpose. So for Black Hills, just as the example, why do we collect your emails when we're at cons? And we tell you we're going to use it for the purposes of sharing our webcasts and our blog information. Now, we can't turn around and we tell you we're not going to sell your data. We're not going to give it to anybody. That's our explicit discussion of what we're going to use it for. If we turn around and give this to a university to do research on where cyber people are on the internet, that's a violation of that principle. And so you can't collect data for one purpose and then use it for another. So I guess Facebook's declaration is going to have to be, there's no telling what we're going to use it for. We're going to use it for everything. So everything all the time, but everywhere.
Facebook does, says Jeffrey. Yes, I know.
All right, so the next principle about data must be accurate and kept up to date. So if your phone number changes, we're obligated to change it with you. If you get an extra cert and we're tracking your certs, we have to keep that up to date. If you have legal things in there set aside, there's an obligation on the people who hold that data to keep it accurate. So that's interesting with the credit reporting agencies, right? Okay, well then show me that you're keeping my stuff accurate and up to date. So I can't wait to drag them in the court.
I know, it's sad to me though, because I feel like there's companies that are too big. They're like, you can't attack the small ones, right? Because, you can, but the small ones kind of like slip through the cracks because they're so small, they're not worth going after. The big ones are like too big to fail. Like Facebook can do what they want. And we know, Equifax, what are the repercussions for that?
Oh, don't get me started. So this is where okay.
It's depressing.
This is a bone. This is a bonus rant. All right.
Ooh, bonus rant.
There are already legal things in place. Like, why can't we sue Equifax out of business, right? They caused harm. They caused damage. And let's see, what's the price of, what's the protection stuff that you get? I got it for the OMB.
HIPAA?
Where they do your credit watch for you, right?
Oh.
So 320 million people times $100 a year. And when the OMB did it, they gave it to me for 3 years because I think my data must have evaporated after that and I no longer needed credit protection. LifeLock. They gave us LifeLock for 3 years, right? So Equifax, LifeLock times 3 years times 320 million people.
Well, and also, like, we blew it, so now you should pay us to keep you safe.
They made it free and everything, but the problem is, so, and I heard that there was days afterward, there were 27 class action lawsuits. If Equifax doesn't go bankrupt, there's something seriously wrong with the system, right? Because we know the legal system has the power, so why aren't they out of business? And give it time. Let's see what happens. But those are the kind of things that already exist in current law. These kinds of things exist. The law's job is to set a broad framework and to clarify, rights and obligations and things like this. But we just keep making more and more and more, yet things don't seem to change a whole lot. And I guess the EU's take is, well, we'll see. We're ratcheting this game up. So, like I said, I agree with parts
the
of
whole
this.
world.
Yep, the entire world.
Next slide.
No, there's a bunch of principles. So these are the core principles. So you think of this is really the guts of what they're saying the law is about. You don't keep data. This goes back to the explicit and legitimate purposes. You don't keep it forever. So if Black Hills goes out of business, that data should be deleted, right? God forbid, I'm knocking on wood. There we go. But you know what I'm saying? So if you collect this for an election campaign cycle, supposedly, right, that data should disappear at the end of that election. However, there's all sorts of caveats and things about historical and academic and et cetera, et cetera, et cetera. But you're going to have to read the law and make judgments and consult attorneys, most likely, especially, like I said, the bigger your company is. Processing only performed under secure conditions. Define that. There are no requirements defined. What does it mean? What's due diligence? What's appropriate security controls? That's all left for us. Although I would posit that best practice is well established in our industry. There are plenty of things you can go get and point to. So, you'll be able to argue those sorts of things in court. So, slide 8. What is really new? So this is my first attempt to be John, where I come up with a little comical thing. There's nothing new under the sun, except for the things we create out of whole cloth. So this right to be forgotten, this has become quite established. That's the bottom part of that. Let me go back up to the top. Okay, data controller and processor. Data controller is the person who's collecting the data. And then let's say you're keeping that with a third-party service in Amazon Cloud. Those guys are the data processor. So you're responsible for record keeping, what went where, when, what policies and assurances that that data processor is also going to comply with the same things. So you're kind of on the hook for their behavior. You've got to have records showing what's happened when you've done things. So there's, again, this is where you get into the guts of a lot of changes. And when you look at people's, software applications, SAP and things like that, you've got to be able to get this data out. So, and then the identification of the legal basis for processing, where you get out of that. So governments have that. They have the legal basis to process your taxes and things like that. But for a company, you've got to get okay, which we're going to get into that notification things where the user said, yes, you can do this. You can use my data, right? So, but the new rights, brand new rights, never heard of them. These are all come from a penumbra of something or other in the Supreme Court, I guess. The right to have your data erased, right, when they're done with it, or the right for you to say, hey, Facebook, I want my data erased. So that's another, maybe I can't wait for this to come into place so I can get that to happen. All those past mistakes.
We all have them.
Restrictions of the processing, they want granular consent. That's in the EU law, is that you can opt in for part of it, but not all of it. So, hey, Facebook, you can process this on my likes and dislikes about restaurants, but not about my political likes and dislikes. So, so you've got to work this into your own. If you're collecting data on your website and you're going to use it for different purposes, people have to be able to pick and choose from what those things are that you're doing. This right of portability was one I didn't really understand when you're switching companies or providers, but when it starts getting expansive, like say with a cell company, right? All your account information and things like that, the right to port it over someplace else. So I guess my electrical utility, when I move in June, I have the right to call them and say, well, send that to my new utility, my new electrical company.
So your whole electrical usage history would go with you to the new address?
I think my electrical usage, they'll probably have a business argument for maintaining that data, but it's about my address or different things like that. I guess if I switch from Amazon to a different shopping thing for books, you know, I don't know what's their data and ours. This is why the lawyers and precedent's going to step in and really show us what does this stuff mean, because it's a little vague. The right to be
lawyers.
The right to be forgotten. I hadn't even thought of this till I looked up that Spanish case, how rough this is for a search engine.
Right? Especially if you were like accused of a crime you didn't commit.
Yep. But even this guy, I don't think he got, I think he actually committed the crime, but he just wanted the right that it's no longer relevant. It has to be forgotten. But for search engines, obviously for the Googles and the dog piles, I don't even know anyone else anymore. Bing, Yahoo. Yahoo's still in business.
There's a shocking number of people that use Yahoo still. It mortifies me.
All those Yahoos. So there is some new stuff here. And like I said, so you got to keep up. And I'm going to get into the data protection shield. It's pretty interesting coming up here. So next slide. Question. Yep.
I hope I said that right. If I didn't, tell me. But what happens if you upload data to a hosting company? They go bankrupt and you can't log in and remove the data, but it's still there. Yeah.
So
I don't know.
So there's a chain of events, and you've got to have contractual agreement. When you hand that data off to a data processor, they have to abide by the same controls. And in those clauses within the contract, should you go out of business or whatever, you're responsible for completing your obligations under this. So that would be the removal, deletion of that data, return of the data, et cetera.
Except for they're going bankrupt, so they don't really, I mean, what vested interest do they have in cleaning the apartment before they move out?
Bankruptcy law steps in and dictates what things you have to do and what priority.
Let's hope it happens. Let's see.
All right. Here's the DPO. Is this what Bob was talking about? Is this the right DPO, Bob? That's one of my favorite Smokey and the Bandit characters right there.
Yeah, so, yes, it is.
That's it. So, all right. So to me, this, and we had a customer that I did this presentation for. I wish they were out there. I hope they're out there. And we talked about it. It's just another hat you're going to be wearing. As if you have a CISO, or if you have a CIO and you don't have a CISO, somebody's just going to put this hat on. You're going to have to declare and probably identify who's your data protection officer. And these duties are, so you're responsible for the bureaucratic stuff around this. You will be the person responsible for reporting your incidents up the chain. You're going to be responsible for kind of driving this through the corporation. You can't do this by yourself, obviously, just like the rest of information security. You're dependent on IT, legal, HR, and in the business operations side for wrangling all this together. So,
Bob points out that the CISO cannot also be the DPO because it's a conflict of interest.
I didn't read that, Bob, but this is why we have a smart audience. Again, reading into that. So I never wear any of those other hats. I delegate that down. So we have a compliance officer. It used to be Kent who's on, but now it's Josh Thomas. So
Bob says we'll chat later.
And then when you get to the conflict of interest in a small enough organization, you'd probably be able to argue that we can't afford to hire a data protection officer. So there is a thing for certain size companies in that law, I believe, talking about that. And again, If they don't catch you, Bob, is it really illegal?
Wow, we didn't just say that out loud.
That was not legal advice.
Bob says, ouch. And Marcine says, maybe I just need to move from security to a bakery. It's getting to be such a risky job. Yeah, I think that would be good.
We lose more good people that way.
Yeah, because the good people just get so depressed.
Hey, Marcy, I have a question. Does your bakery, do they collect customer information?
No, we only take cash.
Cash only basis. That sounds like some of the Colorado bakeries I know. Never mind.
Okay, and Jeffrey says, but don't they say the DPO isn't supposed to be just that in an organization above a certain size? So kind of same thing that Bob said. And Matt said, would it be likely that NIST and US CERT will create GDPR guidelines to modify Appendix A of NIST, specifically 800 through 53? Most of our STDS are built like definition of incident notification times reporting using the NIST and the US CERT.
So the NIST is so broad, it certainly has the controls you need to implement this. However, all the little techniques and fine points around it, it gets beyond just what technical controls you do. How do you implement them? How do you monitor them? Where are they? Again, the standards are there, the controls are there, the best practice is there. It's a matter of you piecing it together and answering the specific questions. So this is one of those things when we write policy. So we do CIS, critical security controls audits, right? And one of the ways to get a better score on that is to write policies that take into account. So you basically have to take the law or the requirement and you have to turn your policy around using the same language, just juggle the words around, and then now your policy is correct. So even if you're NIST compliant and things like that, you still have to do all this, right? There's still a bunch of work to be around it. Now, and when you say you've implemented NIST 800-53, I was in government intel, and we'd say that same thing, but there's exceptions and rules, and it's sort of done, and it's done here, but not there. So again, to meet the law, you've got to get very specific.
And Jeffrey says it's even more about identifying the data and where it sits. Policies and procedures and checks and balances are going to be huge. No
yes,
doubt.
Indeed.
And then we got some funny comments. Holly says, no, not a bakery. I used to manage websites for a bakery franchise. And she says, not a Panera, for sure. But Panera is a bad example. So Marcine says, maybe a funeral home and the customers won't complain.
Hey, that's a good business. People are dying to get in there.
Did it?
Well, it's not as good without the laugh track. All right.
Yay, what? That's just what that was.
All right, let's go on to data breach. So this is what we talked about. You have 72 hours to report. Here's my question. Report to who? So let's say we're Black Hills Information Security.
Hello, EU.
The Data Protection Authority. So if you're in the EU, you get to pick a DPA. So let's say you're mostly a German-based company, right? Likely you're going to pick Germany to be your data protection authority. They're the government entity there, and there's one in every single EU country. And then they've got the problem of, because you've got this idea, your primary data protection authority. So you get to pick that person, and then you only have to report to them, and then they'll coordinate amongst each other, except for when they don't. Because it sounds like this isn't all.
What are you talking about? Government agencies always coordinate with
oh my God, that's right. It's information sharing extraordinary, except it's not. So again, for you on the protection side, and this is one of the big things we preach to people, incident response, right? So this has got to get incorporated into your incident response. Likely, and I'm kind of giving the sneak ahead, likely we're all going to go with the Privacy Shield, and the FTC is going to become our DPA for the US. And we'll see how that works, but we'll see. The 72-hour reporting, when is it a data breach? Is it a breach when you suspect there's a breach? Or is it a breach when you verified there's a breach? Or, because I know it's not a breach when you finally prosecuted the people. So there's some gray in there. But again, if you're going by best practice and you're not purposely trying to evade the law, you're probably going to be all right. You might get your wrist slapped, whatever. But again, so for companies that are working in the EU, picking the right DPA is going to be critically important. If you got enough Spanish-speaking lawyers, having Spain as your DPA might be just fine. But since UK's exit from Brexit, Ireland is the only English-speaking country in the EU. So if you want your attorneys to be able to understand half of what they say, then you'll have to go to Ireland. So try to get Ireland to be your DPA. That's one of the recommendations we have down the road, but I want to make sure I get there. So this data breach stuff, this is major, and this is one of the big things that people are probably going to get in violation of. It's easy to see how 72 hours, and who set 70? That's so unrealistic in some organizations. It's gonna create ready, fire, aim kind of scenarios. But so we can see the problems coming with that. But now you've been informed. Next slide.
Sorry, I already went to the next one.
Oh, you're good. What is the process for requests? So this whole thing that I want my data removed, you're going to have to advertise this on your web page with the consent. Privacy Shield talks about this as well. Your means for removal could be very technical. Google, right? Trying to remove you or hide your results in the search engine. That sounds like a very tall order. So, and again, one of the recommendations, and we'll get to it, is knowing where the data is. Where does it go? I know that when we get to client sites, organization is not our strong suit, and because it's a big, complex world, and we're not sure where things go, but you're going to have to make a good effort at it. So you will have to have processes both on the legal side, like how do they contact you? How do you track that? How do you prove that you completed it? How do you prove that you deleted it? The customer gets to assume it's deletion. If that data later shows up, you'll be dragged into court again. So data protection. Go ahead. We got a question?
Yeah.
Yep.
Well, it's kind of a comment, but Matt says, it will be very interesting to see how Workday and other HR or ERP SaaS, all SaaS, will handle this. In our experience, they will not even agree to properly remove your normal data, much less data from someone who opts out citing GDPR. Not sure how we will successfully modify contracts with large SaaS vendors.
Too bad. It's the law. And if the law says it, then it will be so, despite the technical restrictions. Oh, you technocrats. You technocrats think you will control it all. But no, we lawyers will have the say now. Let's go to my next slide. And this is a planned rant. The data protection impact assessment.
And Matt also says, Ireland. Did CJ really just say Ireland? Cue up Family Guys, my drunken Irish dad. My wife's family is Irish, QED. Nice.
Hey, I flew through there once on the way to the desert, so I'd like to go back. Give me a shot.
It is nice. That's probably good for Ireland that they're the only Irish speaking, English speaking country in the EU.
Semi-English speaking, yes.
Pretty English.
All right, data protection impact assessment. This is the biggest rant. So I worked in government, and we used the government CNA or ANA methodology, where you had to produce thousands of pages of documentation, documenting your security controls and your plans and your processes and your procedures and your policies, and turn them in to a government entity who would review them. And it took 2 to 3 years to get any system approved. And we're going to do this for all the businesses in the world.
Wow. When you say it like that, it's even more ridiculous.
Yeah, right. So the EU is having this horrible thing with, just like everyone else, they don't have enough information security people. So who are the people they're going to have that are going to review this? Who are the wonder kids who are going to be doing this? And so that's why I have the Indiana Jones warehouse scene there. Like, yeah, here's your plan. We'll let you know when it's been approved. Right.
Put it in this warehouse, and then we'll wait for processing.
And then they now have this capability to come investigate you. So they're going to do another audit on you. It's not enough that you've done SOC 2, SOC 2, HIPAA. Yeah, the auditors. Good God, it's a jobs program. Run.
Isn't that the best way to make jobs?
I just cannot wait to see how this is implemented. So my answer on this one, I have no bloody clue. I don't think under the privacy shield, if we do this in the US only, not for our multinational companies, you're going to have to do that. Sorry, mates. But under the privacy shield, we seem to be out from under that. So. The next slide.
This is so depressing,
Cybersecurity.
CJ. This is so depressing.
Hey, I still have 107 people. When I saw it kind of early, it was 103. So very few people have left unless a lot of suckers showed up.
Well, I mean, we're having fun, but it's
that's
super
it.
depressing.
So here's the big, broad, vague. Your personal data must be processed securely and protected from unlawful access, loss, or damage. Use appropriate organizational measures, but those aren't defined. Except, again, I have to go back and argue, we all know what best practice is, but you're going to have to be able to argue it in court, possibly. So this does not establish standards, practices. I think they'll lean on the ISO, but the ISO is such a vague standard that you go back to things like the NIST and hopefully in CJ's dream world, the CSC, which talks about things, but they've got a bunch of other specialized technologies they kind of hint at in here. So we'll see. It doesn't matter if you're the processor or the controller, these things all fine. So here's this great thing, which let's see if CJ can pronounce it. The pseudonymization and encryption of personal data. Pseudonymization, this should be like Pee-wee's Playhouse. When I say pseudonymization, I want everyone to scream. That's where you sort of can obfuscate where that data is.
Jeffrey's screaming.
You give it a number. I don't know. I watched a couple things that mentioned it and talking about it. It seemed like vaporware to me, but it's probably mathematically demonstrable. It's kind of like cryptography, but all I know is if you can do that, that's an out. The other good thing to do, and we've been screaming this forever, if you encrypt your data. So it's not a data breach if you've got encrypted data. So you're doing proper key management and all that great, complex, expensive stuff, and the data gets stolen, leaked out, but they can't unencrypt it, it's not a data breach. So you might want to report it, but you're protected. So a lot of these best practices we've been talking about forever, and that's why sometimes there's nothing new under the sun. A lot of this is just good security. In some ways, this just gives it teeth and a heck of a lot of bureaucracy to go with it, but we'll see.
Bob says they are going to have to form a whole new banking system to store the wads of cash when they start issuing these fines.
Mad cash. And this is where John says we suck at capitalism, right? That's one of our mantras. Look at the bottom. Process for regularly testing, assessing, and evaluating the effectiveness of technical and organizational security measures. This is a watershed event for Black Hills information security business. Buy our stock. Oh, wait, we don't have any. But this does not excite me because this is not the way you want to do it. This is right. This is going to result in compliance testing. So we'll run a scan on you and we'll call it good because we did it. That's not good security, but
Jeffrey says this was written by security testing firms. You're right. We're behind it. What can we say?
Not us. It was the Europeans that did that. European in our pool. All right.
Oh my gosh. That was a dad joke, folks. A dad joke.
I'll be here for the next 12 minutes. All right.
And you were worried it was going to be too short. I told you not to worry about it.
Sorry, mates. What are our risks? Next slide. And I love European lingo. It's like the Brits. They sound so smart when they say things. 20 million euros, that's 24.6 million US in yesterday's currency, or 4% of your annual turnover. Is that apple or cherry? Turnover is that polite British thing, I think, that means your gross revenue, which is not even 4% of your profit, which would be a devastating fine. They're going to take 4% of your revenue. This is where I said, like, holy crud, who voted for that? And
people that don't own businesses.
Socialists that live in the EU. Never mind.
Hey.
I'm sorry. I didn't say that. That's got to be stripped out. Okay. Then you've got this great thing called the Article 29 Working Party, which, right, I don't know who those people, what shadowy group that is, but they're still determining what this stuff means and how to work it and how to implement it and what problem to attack next. So stand by for the guidance and the specifics. I read one article that said this great thing about, well, the purpose here is not to fine companies, but to get voluntary cooperation. You're like, yeah, just
everybody's still, I mean, business is just so hard. It's like, we're not very busy over here. How could we, like,
I know that Bob doesn't have enough. I know Jeffrey Wright doesn't have enough to do. Every time I talk to those guys, they're kicking back. They just, right, they got nothing to do. All right, we already talked about the DPA stuff. And this was kind of a question. I didn't get this changed in this slide. I think the DPA question is answered in the US. It's going to be the FTC from all appearances that I've seen. All right. Conclusions, and this is not the end because I still have recommendations. This law is extensive. This law is,
Wait, what?
Really? It's the Borg. You will be assimilated. The whole purpose of your business it'll be the tail wagging the dog. Going to get ugly. Implementation and standards are ill-defined, but let's just stick with best practice, people. They're not going to be able to get us off that. If you're doing things right, the right way with the right intention, you're going to have to figure out how to tailor it to meet these legal things. But that's just going to be a burden that's going to get added on. Business is going to get more expensive and difficult, like Sierra said. The jurisdictional and extraterritoriality issues. Boy, I have a lot of good things. Supercalifragilistic extraterritoriality. They're unsettled, and let's watch that carefully. I can't wait. May 26th, it's going to start.
Extraterritorial, like you mean other countries?
Outside of the EU's territory. Compliance. Every angle of this, the government, courts, and companies all have their challenges. The government, again, is going to be, they're going to have a very difficult time having the head count to be able to do things. But that doesn't mean they won't make an example out of somebody so they don't have to pay attention to the rest of you rubes. Do beware of hype. Don't let somebody oversell you on this. If you're a multinational, we've got several customers that fall into that category, several. They're already on this. They're well onto this. And that's probably why Bob knows more about this than I do about the conflict of interest on the DPO. They've been doing this. If you're doing this now, you're late. So let's get to recommendations. Seek legal counsel at $350 an hour.
Are you also a lawyer? Matt says, we intend to pay all fines and monopoly money wrapped in OPM clearance paperwork.
It didn't say what currency, you know.
Oh, right. We live in a country where the currency is monopoly money. And Ted said, you don't own your reputation, you don't own your image, you don't own the data others collect about you. Right, and you forgot. In my eye, no doubt. It's sad, but it's so true. Okay, next slide. Okay, so number one, seek legal counsel. That's remember, this is not authoritative what I'm telling you. This is CJ's wild opinion. Somewhat grounded. I've done a fair amount of research and I've been in the business a while, but your legal counsel is manage the risk appropriately. This is my number one, really. Understand your data, your uses and processes and your flows. Don't use it if you don't need it. Figure it out. This is just like your information architecture and your business information, not just this personal information. You ought to know where it is. How do you protect it if you don't know where it is? This is simple. This is simple, people. But simple is not easy, and it never has been. Okay. So that's my biggie. There's this great paper out there on GDPR 12 steps to take now. That's a good thing to grab. Go to the website on the US Privacy Shield framework. I had some slides I didn't get to, but that's the US Privacy Shield stuff, pretty easy to understand. I think it's going to help you comply. It's pretty good, pretty easy to understand. You can self-certify for now. We'll see how that goes. The ISO 27001, there's a mapping to GDPR, and once we've mapped it to ISO, we can map it to CSC, and CSC has the mapping to everything else, so I can help you do that if you're interested. Consider outsourcing, right? Hire third parties, bigger people, outsource that, and they've got to comply. If you're collecting the information on your phone, on your computers, you've got to comply. If you have an outsourced service do that, they have to comply. So Jeffrey brings up a good point. What if you just, somebody forgot to turn their phone off. You want to ignore that?
Yes, I did.
Jeffrey brings up a good point. So what if you just refuse, like stop doing all business in the EU, you block all European IPs, you don't let anybody from Europe even visit your website or participate in any way with your business. which is really scary because it sounds like that honestly might be where this forces everybody to head. I don't know.
It's risk avoidance, and it's not going to work because Klaus is here visiting from Germany, and he
Oh,
accessed
shut up!
it.
Don't talk sense to my like great or Jeffrey's great idea.
Although for
I'll
business,
claim it.
for business to business, that's an approach, and that was one of the complaints. So one of the things they said about the law, if you go get that, I've got a resource in here on this, the critique of the jurisdictional overreach on the Google Spain case, and the part of the purpose of this was to level the playing field. But what they're saying is adding this level of regulation on is going to discourage companies from coming in and doing business in the EU. So it becomes a protective practice. But again, I think the whole world's going to have to comply anyway. Like I said, the Federal Trade Commission's moving in that direction, not that fast, but we'll see what happens. One more slide on recommendations. Establish a DPA if you're a multinational. Ireland is your best bet, I believe, but your attorneys will decide if they'd like to go to Germany for Oktoberfest to present their cases, then that'll be fun. Will the FTC serve in the US? I believe so. See the Privacy Shield stuff. Immediate steps to take. So the Privacy Shield has very good stuff on getting your notifications and things right. BHIS is going to have to do this, Sierra. So work on the notification. Remain calm. All is well. You're not going to jail yet. So you'll just be forking up 4% of your annual turnover.
Oh gosh. No big deal, no big deal. But we have a few more questions, so I don't want, if you can stay,
I've got
go ahead
4
and stay.
minutes.
But I do, some of you do have to leave. So I want to go ahead and announce our winner is Andy Simcoe. If you are still on, Andy Simcoe, let me know in the questions. And if I don't hear from you in the next few minutes, then I'm going to go ahead and announce the second person. But Holly says, so there's a school of thought that just the existence of international treaties or agreements serve as a basis or reference point, even if they aren't completely enforced. So if the fit does hit the
Shan.
there is something to point at and say, see, they didn't like to do whatever, or at least make companies have to justify why they did or didn't do something. This could be similar. True.
Yep. Privacy Shield, though, you have to opt into, and that's been in existence for a while for companies that were transporting data out of the EU to allow it. That was negotiated between the EU and the Swiss government, which is outside the EU, I guess. So all this kind of legal angling of how this applies is sort of established already. And again, it's key. I can do a whole nother webcast on the Privacy Shield. I had another 10 or 12 slides on the Privacy Shield. That's good information. I definitely would go look at that.
Okay, and then Ted says, the 12-step program sounds like a good idea to me. Yeah.
There's some good technology.
Program.
There's companies, yeah. But first, you got to start drinking. And you think there's only Coke Zero in here?
We'll have to drink to get over the stress of this thing.
There's a bunch of technologies out there. There's great ideas like keeping that data encrypted. That's not just to comply with the EU's new GDPR. That's to prevent your data from being stolen and revealed. These are great practices. They are expensive and difficult. So you've got to establish the business case for doing that. But there's lots of things to look at. So,
yeah. It looks like Andy's not here. So the next person on the list is Bryce or Bryce. I feel like it's probably not your real name, Bryce or Bryce. But if you're here, let me know. And the next comment from Matt is, will there be any mapping of attributes like user agent values and or browser cookies that contain a data element that could be interpreted as meeting GDPR protected data?
Yes, it will fall under that. My question is a little over my head.
He's not a lawyer, actually, but he plays one on BHIS webcasts. Marcin says, is it enough if I send my data over email using Gmail to US company? Now that company needs to care about it, right? Yeah.
If they solicit it and they collect it and they maintain it.
But you're using US-based email, so you're almost like participating with a US-based company through another US-based company. It's just so...
if the data belongs to the thing is the citizen, the data owner, the person is the person who's going to complain, despite what channels you got it by. If you knew about it and you maintain it, and maybe even if you didn't know about it, you're still going to be liable.
Oh my gosh. Manny says, is there a portal where CJ is posting his research and material on GDPR? Well, I don't think we have a portal, but you can email him for these slides. And if you have other questions or something we didn't get to, you definitely can go ahead and talk to him. His email is easily enough, cj@bhis.co. And we still don't have a t-shirt winner, so is Tony Mirando here. And we feel like we've picked him before, but we do use Google random number generator. So Kent points out that he's gotten so many privacy policy update alerts and emails this week. It's super obnoxious.
Hey, it's 10 days until GDPR Day, everybody.
So literally everybody's freaking out.
Let's all celebrate with a 1-7
bourbon.
No, you got to drink something foreign.
Oh, limoncello?
Perfect.
Matt says, in the past, privacy laws were addressed by dictating that we follow U.S. law. It gets really hard when GDPR opens the door on all various privacy laws. Example, Australia says no ID cards can have your picture on them. It's a slippery slope, which seems to be consultant and tool vendor feeding ground. Thanks for all the good data.
It's like the religious argument, right? Everyone's going to somebody's hell.
Yes, and Bryce, you're on, so you're our winner.
Yay, Bryce!
You can pick a book, or you can pick a t-shirt. And so go ahead and email me at sierra@bhis.co. And if you want the slides or if you have other questions we didn't get to, you can email cj@bhis.co. And thank you guys so much. Like, this was super depressing, actually, as far as content.
Glad I could help.
But it was a great webcast with you. We had some really good comments and feedback.
Yeah, the crowd was fantastic. That was really nice to have that much interaction.
Yeah, so we always appreciate your interaction. So thank you guys for being on. For Gary and all the people that are new to this one, we welcome you, and we hope you'll come back. We did record this. We'll post it next Monday, I think. We're on our stuff. So did you have anything else, DJ?
Goodbye, folks.
All right. Well, that's been awesome. Thanks again for coming, and we will see you all later. Bye.